Well, this session is going to cover fiduciary, now that we've gone over some of the ethics issues. And fiduciary seems to go a lot with ethics, and certainly for CFPs, because the CFP board has come up with the requirement that we have a fiduciary relationship, which there's a lot of ways to defining what a fiduciary is. So let's just take a look at some of the definitions. There are many definitions of what a financial plan, let's start over. There are many definitions of what a fiduciary is, and different organizations have different definitions. There's some legal definitions, for example, for trustees, for lawyers, for registered investment advisors. There's some that are voluntary, they impose on themselves and have their own standard of fiduciary, such as CPAs and financial planners. Various jurisdictions define and regard fiduciary duties differently, and that becomes a problem when you're working in several different states. So let's say you're in the tri-state area, or you're in the Indiana, Illinois, Wisconsin area. You're going to find different sets of rules of what the courts consider fiduciary. So that's something you always have to discuss with your lawyers. As a consequence, our discussion will be very general in nature and not necessarily reflect any state law or organization using the term. And that's sort of a safety valve to protect me, I guess. But I would begin general discussions. A fiduciary is one who must put together another person's interests before their own. And that's a pretty general statement. And it's pretty indicative of what we say as a financial planner's role as being a certified. But I'd like to go over at the very beginning of the discussion who is and who is not a fiduciary. CFP practitioners are because they've decided to be. Under the legal systems of our country, the lawyers are, believe it or not, fiduciaries. I know a lot of people will disagree with me, but again, that's the law makes them fiduciaries. Registered investment advisors are made fiduciaries by the federal government. And that's something a lot of people are surprised on. What's the difference between a broker and a registered investment advisor? The big difference is the registered investment advisor is a fiduciary. Trustees are fiduciaries, and they probably have by far the highest standards, as along with executors, as far as fiduciary responsibilities. Real estate agents are fiduciaries of the seller, not the buyer. So you go to see a real estate agent and say, I want to buy a house in an area, and they're your best friends. And they work with you to find a house, but what you don't understand is they really are a fiduciary for the buyer. I'm sorry, for the seller, not for the buyer. And I got caught there because they're always so friendly and nice. I assume they're working for me, but they are working for the seller. Professional fiduciaries, which we'll talk a little bit more about later, but they fall under fiduciaries, and that's a requirement of some states. Senior executives at companies are fiduciaries for the company. Now, if you're a statutory employee, such as being an hourly worker or lower level manager, you're not a fiduciary for the company. But if you're a director, senior management type, you are a fiduciary for the company, which gets kind of interesting when people who are senior executives, they many times are on boards of other companies, many times in the same industry, many times you're on the board of a competitor. And in all cases, you must act in a fiduciary relationship for the company that you're representing as a member of their management team or being executive of. And you must have a separate head of fiduciary for being a board of director member. So you have to work very closely on how you keep those interests separate. And by the way, it's very challenging, especially if you're both in the same industry. And most of the time, large companies have some board of director members from competitors because they know the industry. And the question is how much they can do when we have the issue of fiduciaries. And I always advise two things for someone who's being asked to be a director of a company. And as a director of companies myself, I do the same thing. One is I have the liability insurance, And second, I have a disclosure statement that it says exactly what my role is going to be and my relationship with any other company in the same field. And finally, advisors to retirement plans and registered investment advisors. You're seeing a lot of that in the papers today, but I can tell you back in the 1960s, we were already told that if you deal with retirement plans, you are a fiduciary. And I think that a lot of the discussions today about advisors and other people associated with retirement plan being fiduciaries have been true for a long time. Now, what is not a fiduciary? Well, first of all, registered rep. Brokers and sales personnel, backroom personnel are not fiduciaries. They could adopt themselves as fiduciary, and there's some that are doing it today, but unless they voluntarily do it, they're not. Just because a person says they're fiduciary, they're not. My wife is one of those who loves to get more information. She's an information nut. So we get invited to hear someone talk about their insurance business or their mutual funds they're selling, whatever. She loves to go to hear them. And so many of them say, I'm a fiduciary, and they're not, but they say it. For example, there's several insurance representatives she's heard talk about their products and talking about being a fiduciary. Well, insurance agent isn't, because they're on commission, and let's face it, being on commission and putting the customer ahead of yourself is a personal ethics issue besides a legal issue. Bankers are not fiduciaries unless they have a trust department. And if there's a trust department, the trust department obviously is fiduciary. I know that when I talk to people, my clients, they think the bankers are just all interested in helping them, and their best friend is their banker. And I say, I hate to tell you, the banker's in business for the bank, not for you. Then again, the trust department. Statutory employees, again, that's the hourly employee and the low-level management people, are not fiduciaries of the company. Now, they could be agents, and we cover that later in the course. In fact, in most cases, they are agents, and there's certain things they have to do and not do, but for purposes of being a fiduciary, they're not. Financial advisors who are not certified financial planners are not. In fact, an interesting thing about financial advisors is something I read in a financial planning magazine about 15 years ago. The title of the article is, My Plumber is My Financial Planner. And I think I wrote an article about a few years after that was not received very well. It said, My dog is my financial planner. Again, anything or anybody can be a financial planner or a financial advisor. We have no statutory definitions of what these are. So one of the reasons why CFP board is so hard on forcing the CFP trademarks and copyrights, etc. For example, if you got an email address, you cannot use your name with the CFP after it in the address. Is because they want to make very clear they are not just one of those generic financial advisors who have no responsibility. Car salespersons, as I think most people realize, are not fiduciaries. Debt advisors aren't. And there's another one. When you first see a debt advisor, they're your best friend, but their goal is to get your money, not be your fiduciary. And finally, tax preparers. Unless they are a CPA or an attorney, or in some cases enrolled agents for certain purposes are fiduciaries, they are not. So without the special licenses, tax preparers are not a fiduciary. Now, they may in some states be required to fill out certain forms, etc., but that doesn't make them a fiduciary. Again, a fiduciary means you put yourself behind the benefits and behind the rights of your client or somebody else. When does a fiduciary have problems? And this, I think, is the real getting to the meat of it. If conduct may be deemed a constructive fraud when facts, omissions, or concealments appear to be fraudulent, dishonest, or deceitful. In other words, it doesn't have to be an actual case where you did the fraud. If the conduct appears, your actions can affect whether or not you are going to be violating the fiduciary rules. And sometimes people are naive and they say something or do something in a frivolous way. That actually can hurt you, because everything you say or do is going to be looked at. Is there fraud, dishonesty, or deceit involved? Unconscious gain by a fiduciary is identified, and when it is identified, is treated as a constructive trust similar to unjust enrichment. We'll talk about unjust enrichment later in the course, but for this purposes here, remember that if you accidentally make some money that was not appropriate as being a fiduciary, that money goes into a trust. Failure to safeguard the assets until rightfully returned to the principal. Is it going to also be? For example, if I am in an office, there's 4 people in the office with me, and I leave your papers on my desk, and I come back, they're not there, that's negligence. And I'm going to be responsible for you because I lost your paperwork, because you're my client. Again, duty of safeguard. What should I do when I'm not working on your papers? They should put them in my desk, lock the desk, or put them in a file cabinet where I lock so other people cannot get to it. Any profit made by a fiduciary inconsistent with the role of a fiduciary position should be transferred to the principal. And therefore that goes with the trust we talked about earlier. If I make a profit that I'm not supposed to, then it goes to principal, gets it. In other words, we want to make sure the principal is protected, even in areas that are gray, and that's the first one, the constructive fraud type. Appearances are important. If it appears to be wrong, it's wrong. Some basic rules, and it sort of goes on, if it's wrong, is a fiduciary must act in a manner above reproach. And if you are careless in what you say or do, that is a fiduciary issue. Reasonable care must be used, for example, when a prudent person must do in this situation. Not a reasonable person, but a prudent person. A prudent, a much higher standard than a reasonable person. Good faith, being honesty or sincerity of intention, is very important. And finally, due diligence. It says here, personal exercises to avoid harm to other persons or the property. It's really the most important to me is doing your homework, being prepared before talking with the client, and making sure that the client gets the information they need, as well as, again, avoiding any harm to other people. But I think with too often people are not reasonable enough in their actions to be able to take care of being a reasonable person. Next one is profession of fiduciaries. This is becoming a big issue today in most states. Here in California, where I'm located and Cal Lutheran's located, if you want to be a trustee or an executor and you're not a family member and you're not a bank employee who's a trustee or a trust company trustee, you have to be licensed by the state. And California sort of led the nation in this. For some years now, they've had this requirement that you be licensed by the state, which requires you to take certain educational material, be a certain age, and there's certain requirements, but most importantly, you have to take a nationwide test and pass it in order to become a trustee or a executor. Unless, again, the exceptions are family members and people who are with trust companies, trust banks. And I think that it's just worked out very well, because my experience throughout my life is that most people who are trustees and executors don't know what they're doing. They're given the title and they say, okay, I'm going to do it. I've seen where a lot of junior colleges offer, typically at night, courses on how to be a trustee or executive of an estate, and people attend these courses. Sometimes they're very successful. They got good attendance. But I think after the course there were most of the people who have finished it and who understood what they were doing say, I don't want to be a trustee and I don't want to be an executor, which are good statements to say because there's a lot of responsibilities with it. You have a lot of documentation, and most people don't want to get involved with all that. Now, a little bit on the California rule here. California requires, as I said, to be licensed a professional fiduciary unless they're family members or trust companies. Many states reviewing the expansion of responsibilities covered by the licenses, as well as California. They're talking about other areas, and I think power of appointment was one of them. They mentioned power of attorney, another, where we will be required to be licensed again if we're not family members. And it's just a matter of time before that happens, obviously. And as I mentioned, other states are looking at the same thing. And then finally, there's a nationwide testing to prove competency in acting as a trustee is in place. People who are in states that don't require licenses to be a fiduciary still taking it so they have the knowledge so that they don't get sued, quite honestly. I've seen a lot of lawsuits involving trustees, beneficiaries going after the trustee of the trust, and usually the burden of proof is on the trustee, and they usually lose, which gets to the idea of needs for documentation. And just as you as a financial planner need to document with your client, which we talked about under the Code of Ethics, likewise as a fiduciary you have to do the documentation. And the documentation is extensive. Most of the experts in the field who recommend how to keep from being sued by the beneficiaries and third parties say that you document everything and you use a checklist to make sure everything's documented. So you would expect to see, when you're dealing with a trustee or executor, a checklist showing everything they have to do and what they did and when they do it. And usually attached to that is a loose leaf folder that contains all of the documentation involved. So it's not a simple thing. I know we've had situations where I've been asked, because I was a financial planner, if I would be a trustee for someone. The answer has been generally no, because I know the amount of work I have to do is extensive and ties up a lot of time, and quite honestly, it wasn't financially worth it for me. Now, when I started my practice back in the early 90s, I did trust for lawyers I dealt with because they got me most of my business as financial planners. As I was a financial planner, they got me my business, and the quid pro quo was I took care of some of the trusts for them. I got paid for doing it, but it was very time consuming, and I think that even though there's a lot of push by some organizations to have financial planners do trustee work, I was certainly thinking about it and get educated in it before accepting that role. So let's, as a conclusion to what we're talking about, what the students should understand after completing this module. Ethics are a requirement in all professions that must be taken seriously, especially in the field of financial planning if you're a certified financial planner. Now, in some industries and some organizations, ethics don't mean much. In fact, as I mentioned earlier, ethics in many organizations are hard to find it. It's someplace in their paperwork, but how much actually gets to you is another issue. I'm a member of a Chamber of Commerce, and I got all the paperwork at the beginning, but it never mentioned their ethics standards. And yet I know they have it because I've seen it in the past before joining it. Again, I had to ask in order to get a copy. And I think if you belong to an organization, you would be smart to ask to see what the standard ethics are. Now, the other thing you'd have to know is whether or not they enforce it, because again, it's not a legal requirement, it's a organizational requirement. Some organizations have ethics standards but completely ignore it. Others do not ignore it, go to letter that dot the I's and cross the T's. An example of that is the mafia again. You disobey one of their rules, you get punished for it. And I think the CFP board is getting just as bad because if you look at all the cases they've been having lately. The CF board has published a list of ethics which the practitioner is expected to know and follow. That was covered in the first part of this session today, and it's going to be covered on the quiz, and you're also going to see it when you take your capstone course, if you haven't already taken it. And then finally you're going to see it when you get into practice, as well as the CFP exam. Fiduciary responsibility can be posed or taken on voluntarily. Again, the real issue is how complicated it is. In some cases, it might be as simple as just put the client before yourself. In other cases, it's a very extensive list of things you have to do. And again, I like to show the example of trust. For those of you who are interested in trust and how complicated it is, go on the internet and look up the restatement of trust. And there's several restatements, but anyone you look at will show you the complexity of what you have to do to be a fiduciary of a trust. And again, others are in between. The fiduciary responsibility of an attorney, even a teacher has a fiduciary responsibility, but it's very narrow. And so, again, you have to find out what that responsibility is based on your profession and the associations you belong to, and also if there's any legal requirements that you may not realize. And finally, financial fiduciary responsibilities do vary, but there are certain basics. Again, the most important is putting the other party before yourself. Well, we've covered a lot of material this first week that is very important. Again, not only for the exams, but also for your business, and also the fact that many times you're going to have legal help, and we're going to start on legal help in week 2. We'll tell you when you got to get legal help and how to use it and when you need it, etc. So let's this first week emphasize our responsibilities in the areas of ethics and in fiduciary relationships. And with that, I say good luck.